pledge.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, roll call.
Okay, Ms. Dungeon.
Present.
Ms. King.
Present.
Mr. Dawson.
Present.
Mr. Siebold is absent. Mr. Johnson.
Present.
Thank you. We have a quorum.
Okay, we need approval of the minutes in the last June 11th meeting.
So moved.
Second?
Second.
Okay. I don't think we need to vote, do we?
Okay.
All right, anything under old business?
Mr. Chairman, I would like to propose we amend the agenda today to hear the appeals first and then to address old business.
There's a second to that?
Second.
All those in favor signify by saying aye.
Aye.
Opposed? Okay. All right, so we're going to go to appeal number 5.
Okay. This would be appeal number 13308 by DeMarco Landingham and Devin Harden, tenants on behalf of Roderick Jones, an owner concerning a property located at 1956 Buffalo Road. Index number is 15-2123-114 in an RLB Residential Limited Business Zoning District. The appellant is requesting approval for a commercial recreation use per section 204.14 of the ordinance. Commercial recreation is not a permitted use. Gentlemen? You guys can come on up to the mic.
All right, you come over the microphone here, please. And the court reporter will swear you in. Can she hear me?
Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Before you speak, give us your name and your address.
Marco Lanningham, address 2625 Prospect Avenue, Greater PA. 16510.
Devin Harden, 304 East 29th Street, 16504.
Roderick Jones, 2811 Wayne Street, Erie, PA, 16504.
Okay, you want to tell us what your plans are for 1956 Buffalo Road?
Yeah, it's just
You
dog,
speak nice and loud into that microphone so she can hear you, please.
adult recreational facility, primarily with just skill games in it, approximately about 15 games. We are not serving any food, any beverages, any alcohol, anything like that. It's just a facility for adults to come in their leisure, play games of chance, and leave at their leisure.
So these machines are what you see in convenience stores around town, Lucky's, so on?
Yes,
Same
sir.
kind of machine, a gambling machine?
Yeah, games of chance. Yes, sir.
of chance.
Okay. What will your hours of operation be?
Primarily from 7 a.m. to roughly about 9 or 10 p.m. Monday through Sunday, every day.
Monday through Sunday, 7 days a week?
Yeah.
So you're going to say 7 a.m. to 10 p.m., is that what you're saying?
Yes, sir.
And these games of chance are regulated by the Commonwealth
Yes.
through the lottery system?
Not through the lottery system,
No.
no.
Anything else?
Yeah, I thought
Nice and loud.
okay, I didn't think I heard that they were regulated yet. I could be wrong.
I could be wrong. As far as I know, they are regulated. We're not sure. But what I can.
I think
but
on the
what I-
news, today, they spoke to the fact that they still haven't come up with them being regulated yet, and that the governor wanted 42%, and that because he didn't get that, it was stalled, and so thus it hasn't been agreed upon. What do the skills games qualify? Are they skills games or gambling machines? I think that's what I heard. Is that what you heard?
That sounds, I didn't hear particularly what you
Oh,
heard,
okay.
but it sounds accurate, though.
No, the only reason I'm asking, Chair, because you ask the questions, is this regulated? And I don't think the answer is yes.
I think that that's correct.
Thank you.
I don't think that there's any specific regulation on these games right now. There was a Commonwealth Court decision that said that they were legal.
Right. That's what I meant when I answered that. I'm
Right.
sorry about that.
Yeah.
Good.
So you're not going to be serving or selling any food, any beverages, anything like that?
No.
Are people going to be allowed to bring in their own food and beverages?
Absolutely, if they would like.
So people could bring in their own alcoholic beverages?
We're not alcoholic beverages, just food, drinks, soda, things of that nature, chips, whatever.
Are you currently operating at that facility?
Yes, and that's one thing we wanted to apologize to the board about, and also the city. We through ignorance, we didn't know that we needed to be zoned for those games to be going through here, saying, well, that's where we dropped the ball at. We should have came down here, got the facts, and went through the proper processes, and got the zoning the way that we were supposed to, so.
What are the properties adjacent to you?
There is is that a VFW? There's a post and also a church next door.
Okay.
Yes. I like that.
Gentlemen, are you familiar with the criteria for granting a zoning variance? Have you reviewed that criteria?
That was sent to us, yes, we did review it.
Okay. So you're familiar with the concept of an established hardship?
An established hardship?
Yes.
I'm not familiar with that, the definition of that. I did read that, but I don't know what an established hardship is. If you may explain it.
So the issue, one of the issues with a use variance is, if you're just looking at it from a use variance perspective, is whether or not it is possible to use that property for something that is permitted by the zoning ordinance already, okay? So you want to use this as commercial recreation, which is something that is defined under the Erie County, the City of Erie zoning ordinance. And there are areas within the City of Erie that are zoned for commercial recreation, okay? So if you wanted to take a building in one of those areas where commercial recreation was authorized and open up this type of a business there, you wouldn't have to come through and get a variance, okay? So permitted uses, Amy, this is an RLB?
That's correct.
Okay. So Permitted uses here would be a one-family dwelling, two-family dwelling, multifamily dwellings, banks or financial institutions, accessory uses and structures, adult daycare, bed and breakfast, business offices, car wash, a church, place of worship, cleaners, computer use centers, community garage, convenience store, corporate office, daycare centers, eating and drinking establishments, essential services, fee simple townhouses, fitness center or gym, florist, funeral homes, greenhouses, group care facilities, home child care, home occupations, hospitals, ice cream shops, libraries and museums, licensed massage therapy, limited retail business, medical and dental clinics, mobile home parks, off-street parking lots, personal care boarding homes for adults, personal services, public/semi-public uses, professional services, rooming and boarding homes, short-term rentals, urban gardens, utility stations, video rentals. That last one shows you how old this ordinance is. They're still doing video rentals, right? But then you've got other special exceptions and conditional uses, none of which include commercial recreation. So, is there a particular hardship, something specific about this property that would prevent it from being used for any of those other uses that would be permitted, or special exceptions or conditional uses? What is special about this that requires a zoning change? So if you wanted to have a convenience store there and have these skill games there, because they are in a lot of convenience stores, probably wouldn't be an issue. But you're looking at this as just a commercial recreation spot. So the question is, what's special about this property that would require a change in the use that is permitted under the zoning ordinance?
Okay, so, y'all want to weigh in?
You speak up right into the microphone, nice and loud, please.
There's nothing in particularly special about it. You said personal uses as one of your things on your list. Could you elaborate a little bit on personal
You
uses?
have personal services
Personal
defined.
services.
Yeah, I'm going to have Amy take a peek at that under the zoning ordinance.
And while she's doing that, I can weigh in that at one time it was a bar, before it was a daycare. And,
Well, and an eating and drinking establishment would be a permitted use in that neighborhood. So if you had a liquor license, now I don't know if skill games are something that are permitted in a bar. So if you had a liquor license, you opened up a bar,
Right.
then you'd probably be able to have them there. Go ahead.
Ready? Okay. Personal services, any commercial establishment providing services pertaining to the person, his apparel, or personal and effects commonly carried on or about the person, and including automatic teller machines, excluding drive-in facility, shoe repair, tailoring, and clothes cleaning on the premises brought to the establishment by the customer. Massage parlors or adult uses shall not be considered personal services.
And the reason I asked about the hardship is, it is not the role of this board to decide whether or not we think this is a good idea, right? Whether or not it generates jobs, economic development, any of that. Our purview is, does it meet the criteria that's established in order to grant a variance? And we have a very narrow scope of what we can decide here.
what I can say is that, there is the same kind of facility within 2 or 3 blocks of our facility. And I don't know what that would fall under, but there are several facilities in the vicinity of this skill game spot that I guess I have already been permitted or granted permits. There's one right on the corner of McClellan Avenue that's strictly skilled, games of chance inside of it. There's no food, no drinks.
Really?
There's no convenience store, and I went,
Which one you're talking about? I do believe there was convenience store listed on the use at the time. I would have to confirm with the building inspector.
Can I ask a question? So if they had opened up, per se, a convenience store, they wouldn't have to have a variance or a hearing to actually have that business, right?
No, a convenience store is a permitted
Okay,
use.
so-
Now, if the place that you're talking about opened up as a convenience store and is no longer a convenience store, then that's an enforcement issue.
That's
And that would be a problem,
We can talk about it.
yeah.
Right. Okay. But
So, and
there-
I'm sorry, I didn't mean to interrupt you,
No,
sir.
so there again, so what I'm saying is, if it's a convenience store there, with the skill games there.
Yeah.
We don't have this hearing today, right?
Yeah,
Okay, let's do
Anything that's a permitted use under what Mr. Arnucci
trying to
read.
open a convenience.
That's what you,
Yeah.
sell some chips.
here's,
Because we have the facility for it, it's room for it.
here's a copy of the permitted uses from the zoning ordinance for an RLB district, okay?
Okay, have a good day.
So do you want to withdraw your appeal?
Yes, we'll withdraw the appeal and we'll let them come get permits for their convenience store.
Okay.
If you guys give us the
Hopefully no
office a call,
quotes.
get, started on it.
Hopefully no quotes, just convenience store.
No, we'll survive. Thank you.
Okay, thank you.
Thank you.
Okay. Moving right along. Next appeal.
Okay, next appeal, 13309 by Quan Jones and Curtis Carson concerning a property located at 802 East 11th Street. Parcel index is 15-2039-217, located in an R2 medium-density residential district. The appellant is requesting approval for a convenience store with Skills Lounge use. Per section 204.12 of the ordinance, convenience store and commercial recreation are not permitted uses. Thanks, guys.
So, gentlemen, if you would, is the court reporter prepared to swear these gentlemen in?
Yes.
Okay, if you gentlemen would just raise your right hands. The court reporter would
Do
go
you swear
ahead.
or affirm that you're,
Go ahead.
for the record, do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes. Thank you. And as before, just state your names before you start to speak.
Curtis Carson. Jaquan Jones.
Okay. Is somebody going to be the primary spokesperson?
No.
Okay. If you would, just because the court reporter is remote, just like one person at a time, and then make sure you identify yourselves as you begin to speak, okay? So whoever wants to proceed first.
Go ahead and just pitch in if you want to talk. I just go ahead. Basically, my name's Jaquan Jones. I'm part owner of 802 East 11th Street. We're basically opening up the building for commercial use. I mean, as far as skills gaming and a convenience store. I've talked to the neighbors in the neighborhood, and that was something that they wanted us to do around there. So that's basically what we're here for today, to get it zoned for that. We haven't been open or anything, trying to open or anything like that. So yeah, I talked to a few of the guys, the zoning guys, and they told me the steps to do. So that's why we're here today.
What was the last use of the building?
It was like an after hours, like somewhat like a club then,
How long has that been shut down?
like 6 years, 6 years. It's been a while.
It looks like back in April of 2018 that the zoning office had a cease and desist on that property being used as a bottle club. that's not your intent?
No. No, sir.
So similar to my question to the last appellants, we have very specific criteria that we hear, right, relative to granting a variance. One of those criteria is to establish a hardship. This property is in a R2, which is a residential zoning district, and we can go through the R2 permitted uses if that would be helpful to give you some context there, but it is still incumbent upon the appellant to provide unique characteristics of the building, why it can't conform to the permitted uses in R2, what is that established hardship, right? Again, it's not our role to weigh in whether we think this is a good idea or not. Our role is to grant or deny a variance based on that criteria that's in front of us.
Basically, we're just trying to create a community, a good environment for the community. That's basically it. Just change the narrative of what was going on around there and give somewhere for the community to come to get some, like as far as snacks, chips, and being able to, just being able to, if they, at their leisure, if they want to do some skills gaming, they can. That's basically it.
I think it would be, once again, appropriate if you just list what falls under the heading. It doesn't appear that you folks know what falls under that heading of what's permitted as a use. And if he just goes down the list again.
Sure. So this is a different district than the last one. The last one was residential limited business. Your district here is R2 medium density residential district. So the permitted uses are one-family dwellings, two-family dwellings, 3 and 4 family dwellings, accessory uses and structures, bed and breakfast, cemeteries, churches or places of worship, community garage, essential services, family daycare, fire stations, home child care, home occupations, neighborhood center, off-street parking lots, parks and playgrounds, short-term rentals, townhouses, urban garden, utility substations. The special exceptions are group homes, market gardens, planned residential development, schools, small wind energy systems, and wireless communication facilities. Do you gentlemen own the property, or would you
Yes.
be? Okay. And when did you purchase it?
Wow.
Was it before it was shut down in 2018?
Yeah.
Okay,
And we had it for a while.
okay.
Go ahead.
Considering the area over there, I know what we have here, but I'm thinking about the neighborhood and access to food in the area. What are you planning to sell besides just being a convenience store? What kind of foods will you be carrying?
They need that around there. Just
Exactly.
Yeah, they need it totally. I mean, I've spoken to the neighbors, and they all come around and talk to me a lot. Due to the fact of what was happening there before, so they let us know like what they would like there. And when we mentioned the convenience store, they were all for it. Due to the fact that there would be coffee there, they can come and get in the morning. They can send the chips and candy around there, cold subs, just things for in that neighborhood for the community to come and get. You know what I mean? They don't have to go all the way over to Country Fair or cross the Bayfront connector to get over there to 10th Street or anything. It's just right there at their leisure and their convenience. So that's basically what we're trying to bring to them, including the skills games.
Any other questions from the board?
I guess I just wanted to hear again the hardship. Do you know why you request a hardship?
Meaning what? What do you mean by hardship?
Well, what prevents, what about that property prevents it from being used for one of the permitted uses or the special exceptions in an R2 district?
Some of those things it can be, but like as far as the garage, we have a garage in the back. We could do things like that as far as washing cars and stuff there. You would have to convert it. You know what I mean? It would take money for it to be converted into a few things. The convenience store would be a lot easier. It would be easier to open, for the public to come there as soon as possible. A lot of things, it would just keep the building under construction for a longer time, doing things like that. But the convenience store would be easy to, get up and running and stuff like that, just to give people in the neighborhood somewhere to shop. And, it's walking distance.
Has there been anything in the building since 2018?
No.
And did you hear convenience store as a use?
Yes. No, I didn't. No.
RLB, again, if this was RLB, then absolutely, you wouldn't even have to be here for a convenience store. But because it is R2, it would be a use variance, and we do have some strict criteria on those. As long as there are other areas in the city where you could open up a convenience store, then we have to look at those very strict criteria for this. Okay.
Any other questions from the board members? Anybody here else to speak in favor of this variance? Is there anybody else here to speak in favor of the variance? Anybody else to speak in favor of the variance? Hearing none. Is there anybody here that's opposed to the granting of a variance? Anybody here that's opposed to the granting of a variance? Anybody opposed to the granting of a variance? Hearing none. Do we want to caucus, or do we just want to vote on this now?
Up to you.
Let's vote.
Okay. Ms. Gunchen?
Denied.
Ms. King?
Yes.
I'm sorry.
I'm voting yes.
Thank you.
Yes.
Mr. Dawson?
I'm going to vote yes.
And Mr. Johnson?
I'll vote yes.
Okay. Motion has been
Thank you.
granted.
Thank you.
If you guys want to give me a contact, I'll just set up and move along.
Can we get your number, please?
Yes, if you ask the front desk for my number, they have my card up there.
Okay.
Okay, thank you guys.
Appreciate you guys.
Yeah, I'm the email, when the email, Jeff. Thank you.
Okay, we are back to an appeal that was continued by the Perseus House, am I correct?
Yes.
Yes,
Yes.
correct.
The two didn't show up, right?
The short-term rentals they're still on the table.
They're both tabled.
Yeah, they're still on the table.
Do we have to say that so it's in the record?
No.
Okay,
They just remain tabled.
good.
Okay, you want to read appeal number?
Yes, absolutely.
306?
Yes, this is tabled from June 11th, 2024, appeal number 13306 by Gary Ivan, Esquire, on behalf of Perseus House, which are the proposed buyers concerning a property located at East 42nd Street and Dexter Avenue. Index is 18-5244-300 in an R3 high-density residential zoning district. The appellant is requesting approval of a group care facility, and per section 204-13 of the ordinance, group care facility is not a permitted use.
So by way of just a brief recap, this is a continuation of the hearing that was begun on this particular appeal in May, in June. And at that point in time, we'd heard some testimony from the proposed buyer on behalf of the property owner. We'd also heard testimony from several of the residents in the area that were opposed to the variance request. At the suggestion of the zoning hearing board, Perseus House held a meeting with interested neighbors yesterday at Perseus House that went from around 6 o'clock until quarter till 8 rather, my apologies. And there was a good discussion. I believe that parts, if not all of it, were available to view. And that's where we are today. I think that Perseus House did follow the request of the Zoning Hearing Board to have that dialogue with the neighbors. I don't know what, if anything, was resolved, but here we back are today. So I suppose, Mr. Ivan, if you want to come up and for the court reporter, Attorney Ivan is the representative of Perseus House. As an attorney, he's always under oath and does not need to be sworn.
Thank you very much. I think first I need some clarification as to what our procedure is going to be here today, because we have completed our case. We're done with our presentation, and at the last hearing, you did invite members of the public to come and speak already. So I think those portions of it have been concluded. If you wish to open it up in any way, we will not have any further evidence to present. So I'm not sure what you want to do at this point. If you want some legal argument, I prefer that await until the conclusion of the complete evidentiary case.
Okay, and I think that that's what we'll be looking for right now, would be legal arguments. So if you want to step back, we will open it to anyone who did not have an opportunity to speak at the last hearing. Either for or against.
Okay, I just want to make sure I heard that correct. It's open to those who did not have the chance to speak before.
Yes.
Thank you.
Is there anyone that did not have a chance to speak before that would choose to now?
In favor of the...
Come forward.
Either in favor or opposed to, whichever. It's a large moth.
It's a very large.
Hi, I'm Kurt Sundberg. I'm an attorney here with Marshoff Law Firm. I represent Dola Real Estate Company, which is the seller and current owner of the property.
You speak up a little bit, Kurt.
I represent the current owner of the property, Dola Real Estate Company. And just wanted to get some information to the board. I guess there's the legal argument you'll hear from, I think, Mr. Ivan, is the fact that group care facilities are only allowed in an RLB district, which is a very limited area within the city. Group care facilities aren't permitted or not listed as a special exception or a conditional use in any district. So there's just this limited RLB district that allows, which is a residential limited business district that allows group care facilities. So I think that's part of the legal issue you have, is whether there's exclusionary zoning going on and not giving a reasonable amount of property or land for this type of use. But to the facts and circumstance of this matter today, I think it's important to note that a number of the neighbors that have objected to this variance are doing that based on some misinformation that was circulated by a flyer as to the intended use of the property. The flyer that was circulated amongst all the neighbors saying, we don't want this, we don't want that in near our neighborhood, was misinformation because it's not what Perseus House intends to use the property for. And the fact of the matter is that their intended use is really the best and the most attractive use of this property. It will be designed and it will look like a small residential subdivision. These will be brand new residents that'll be used as a group home. So it'll be an attractive look, and it will be a continuation of the neighboring properties with its look and design. Again, the permitted uses in this district allow apartment buildings, dorms, those type of things, and will allow an apartment complex, anywhere from 40 to 100 plus units. If Perseus House isn't given the variance to build this nice, attractive residential, small residential subdivision, basically is what it's going to look like, Dola Real Estate is going to sell this property. They don't have any plans to develop it, so they need to sell it to a developer. The most likely developer that it would be sold to would be somebody that's going to build anywhere from 40 to 100 plus unit apartment complex. That being a permitted use, they would not have to come to the zoning hearing board to get any type of variance, and would not be subject to any reasonable restrictions or conditions that the zoning board could impose. They could build, towering apartment complex that would, really take away from the neighborhood's look and feel. You would have significant traffic increase with an apartment complex. You had a significant increase in impervious material. I mean, naturally, the parking lots and asphalt and concrete that would have to be built for a 100-unit apartment complex would significantly increase the impervious area, and planning with regard to stormwater management definitely would increase significantly the traffic flow. So what Perseus House is proposing, again, residential appearing homes that have anywhere from 4 to 8 occupants, you would have much less traffic impact, much less stormwater management impact, because there would be much less parking lot area, impervious area. And also Perseus House's proposal as to the type of use, you would have a specific type of person that, a teenager that's just dealing with depression or anxiety and is getting counseling for that. Naturally, with an apartment complex of 100, you're going to have all types of people. You're going to have the good and the bad that you would have in a complex that size. And again, if an apartment complex is built, there wouldn't be a process like this before the board. The developer would not have to seek and address any concerns of neighbors, would not have to seek and address any concerns of the board. Perseus House is coming through this process with an understanding that they will accept the reasonable conditions and restrictions with a variance, because the board has the right to do that. It's expected. And it's expected that the board would impose reasonable restrictions and conditions with granting a variance that would address the neighbor's concerns, and also allow an attractive and beneficial development to proceed. It would definitely benefit the area. So, if the board says, yes, we're going to grant this variance, but we want increased setbacks. We want a green zone with trees and gardens or lawn space. Again, Perseus House, my understanding is based on the plans, is taking into consideration that an extra green space, extra plantings, extra setbacks, those type of things, of space between their project and the neighboring residential area. So again, this process will ensure an attractive, a positive, beneficial development of that property. Whereas if this project doesn't go forward, there's not going to be any control over what type of complex is built there. And I think that, and again, if there are concerns of neighbors as to particular uses, I think that the board, again, with granting a variance, has the right to put some use restrictions, reasonable use restrictions in there too, to address some of those concerns. So I just wanted to kind of express that and indicate that there is a way for this project to move forward with reasonable restrictions, with reasonable conditions. Again, green zones, setbacks, use restrictions, those type of things that will make this a very positive, enriching project that will benefit and enhance the neighborhood that right now is looking at the back of a plaza. And this is going to be a much more attractive development and appealing. Okay? Thank you for your time.
Attorney Sundberg, just one quick question for you. How long has DOLA owned that property?
They have been owned it for several years, and DOLA Real Estate Company had originally planned to build an apartment complex there and had gone into planning phases, and it was going to be close to a 100-unit apartment complex. But because of a various number of issues, parent illness and passing away, caring for parents, project plans, and with DOLA, the real estate is not just a real estate company. They have another business that, a development business that, water and sewer line installation, that type of thing. They're busy with other projects like that. For reasons retirement, getting to an age where taking on a project like this just didn't make sense at that point in their lives. They just never pursued that. But again, it's they think that if Perseus House doesn't do this project, then the most logical buyer for them is going to be an apartment complex developer.
Okay. Thank you.
I just had two questions, actually. Do you know what protective measures will be put in place with the stormwater and drainage issues in the area, and then anything as far as protecting the environmental? I know some of the neighbors had concerns about that, to ensure that, like, the green spaces, I know you mentioned us putting conditions, but there are some animals that are in the area that they want to make sure are still there. How can that be maintained with the construction?
When you kind of look at it, it's kind of a vacant parcel, not a whole lot of, I think there's some trees along the border that naturally would not have to be disturbed with this project. But this project is, like I said, it's going to look like a small residential neighborhood with lots of grass, plantings. They're not going to just have grass and homes. It's going to look like an attractive neighborhood. So there will be trees, shrubbery, gardens, that type of thing. That, again, I live in a residential neighborhood, and we have deer coming through our yard all the time. I would kind of envision probably an increase, in the squirrels, the birds, the even deer, that type of thing that would be going through this area, as opposed to, again, if it's an apartment complex that's a majority of buildings and parking lots, you're not going to have that green space for wildlife.
Ms. Benson, you have a question?
Sure. Other than Perseus House, have the owners had any additional interest in the last 10, 15 years for development?
Yes. And again, if this project doesn't move forward, then they're going to explore those interested buyers, that have been kicking the tires, that are apartment complex developers. So again, that's why I say this project is the best use of this property for that area, considering the neighborhood that's close by, because it's going to look a lot like a neighborhood, and I think it's going to enhance the value of the properties because, like I said, right now, they're looking at the back of an apartment, a strip mall, basically, kind of is the view that across that lot right now.
Thank you. Ed, do you have anything? Anybody else on the board?
I just have one comment to that answer. So you're familiar with the criteria for the variance. I sound like a
Yes.
broken record today, but you're familiar with the criteria for the variance. So my question was very pointed in that, have they had other interest in the development? And you said yes. So my assumption then could be that the property can be used for its intended purpose, which is the permitted uses within that district.
Yeah, yeah, it can be used for an apartment complex, and a very large apartment complex. I think with regard to, I think that's the legal argument with regard to Percy's house is the fact is that exclusionary zoning issue, that there really isn't any area provided for in the city of Erie for their type of development and design. And so, and quite honestly, in that district that it's permitted, it's quite possible that there really isn't any property that they could do that type of development. So that's the hardship that they're having is that, hey, look, what's carved off in the city of Erie, this little small area, is not workable. It's kind of similar to like if the townships that say, we don't want mobile home parks, so we're going to just give this little corner of the township that you can put a mobile home park. And the courts say, well, you're really not providing a reasonable amount of area for this type of development, and you have to provide for all types of development. And that's really the hardship you have in this case, is that Percy's house, this property will work for their type of development, but there's really nothing else available.
Thank you.
Thank you.
Okay, thank you.
Well, if there's anyone else to speak for or against it, you at.
For anybody that hadn't spoken.
Right. So if there's anybody here who hasn't spoken before, for or against, that wants to present now. I do. Well, why don't you come up first, ma'am? You stood up first. And then you can. That's okay.
You don't have those mother eyes in behind your head.
If you would state your name and address.
My name is Kate Kager, and I live at 146 Cypress Street.
Okay, before you go on, the court reporter would swear her in, please.
You swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Can you spell your last name for me, please?
It's Kager.
Thank you.
So I don't live right there, but I have power of attorney for my mother, who lives right in that area. And if I thought for a heartbeat that this would be a problem, I would be standing up here saying, no way, I would be pounding my fist on the table. I think we have a real problem with mental health in every city in the country. And if they want to build a state-of-the-art facility, and that's a space to do it, and last night they showed the housing, and it's houses. It's a nice looking, it's going to be a neighborhood. It's not a jail. These are not kids there because of the courts. These are not evil kids. They're kids that are getting their minds tended to. And I'm a nurse also. That is so important. We don't tend to think that brain health is important. And I just want to say it is. These are not the kids that shoot up the schools. These are the kids that are getting help. The kids that do the shooting didn't get help. These are the kids that are getting help. Percy's house does great work. And what they want to do is put in a state-of-the-art facility. And I don't believe that they're going to put up, razor wire. It's not going to look like down on Ash Street. It's going to look like part of the neighborhood. And these kids are already using Horton Park with supervision. Cripe, they've got better staffing than the nurses do. I think it's a good thing that we even think about letting them build such a facility for these kids that really, really need it. So I'm for it.
Thank you, ma'am.
There's another lady over here. Your name and address, please.
Sure, it's Renee Brown, and it's 4150 Essex, 6504.
Okay, if the court reporter would swear Ms. Brown in? Raise your right hand.
Swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes. I would like to start by offering a total of 236 signatures of addresses of people in the area who are opposed to this being built there. I also wanted to bring up a couple points. First of all, this development is not seeking the minimum variance that will afford relief, since it is a large-scale request beyond any permitted use. Also, this development will alter the essential character of the neighborhood, since it will leave 45 to 100 future residents with inadequate green space to recreate. Per the ordinance, a group care facility development is not permitted there. Finally, from the PA Municipal Planning Code, since this proposed development property has many other uses available, it is not limited in that it cannot be used for permitted use, or that the property is valueless for any other purpose permitted by the zoning ordinance. Could DOLA sell it to a developer who's going to build a 100-apartment complex? Maybe, possibly. Could a developer also come in and offer single-family homes and turn it into a neighborhood? Maybe. We don't know. That's not a point that we can argue who's going to build there, because we don't have somebody else who's going to build there. It could go to apartments. It could go to single-family homes. So in my opinion, that's just a moot point. So did you guys want the signatures?
If you're presenting them,
Yeah.
Amy will take them.
We have copies of them. And that's it.
Thank you very much.
I have a
Thank you.
question.
Have a question?
Yes.
Yes.
So you've heard them describe that they could put a 40 to 100 unit building there. Is it that your preference for it to stay as it's supposed to be utilized?
No, I'm just trying to point out what it can be used for.
And I'm asking, you're in favor of what it can be used for then?
Well, yeah, I guess. But as like I said, it's not currently, doesn't have the proper zoning now, so why would we have to change the zoning if it can be used currently?
Correct. So if I put a 40 to 100 unit building there in your neighborhood, you would be okay with it?
That's what it's zoned for.
Okay, thank you.
What? You haven't been heard yet? Your name and address?
Jack Bernard, 4116 Burton Avenue.
Let me get sworn in.
The court reporter, yep.
You swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
I do. I've lived at 4116 Burton for 26 years. First of all, I do want to say, as many of us in our group believe that Perseus House provides a great service, does great work, and it's not what they do, but where they want to do it. And we just don't think that it's a good fit for our neighborhood. I'd like to cover three areas. First being traffic, and all you need to do is come and spend a few hours on Burton Avenue sitting on our front step, and you'll see the volume of traffic, the speed of the traffic. Burton Avenue is posted at 25 miles per hour, as which with many of the other streets in the city, that's not adhered to. The average speed coming down Burton is probably 35 to 40 miles an hour. I've been at times mowing the strip of grass between the sidewalk and the street and had cars go by me at 50, 60 miles an hour. So my only point is, it's a busy, dangerous street, and the proposed Perseus House development cannot help but add traffic to this area.
It's a 24/7 operation, so traffic at times that are where we wouldn't have that much traffic, we'll have more traffic. Specifically on the side streets, the only access to this property is from, as I understand, the main entrance will be on Dexter. There's two ways to get to Dexter, off of Pine Avenue, which I didn't even know until I started researching this, actually intersects at Pine. If you go up to the top of Dexter, there's a sharp right that takes you over to Pine Avenue. I never knew that was actually part of Dexter Avenue until we started researching this. So other side streets close to the area are currently very quiet. I mean, people walk themselves, they walk their children, they walk their pets, they ride their bikes, and they're very quiet, not too highly traveled streets. And I'm referring to 41st, 42nd, and of course Dexter. That will all change, again, with a 24/7 operation, up to 100 beds, support staff, deliveries. If this were any other type of 24-hour-a-day operation, we'd still be here opposed to it, whether it was Perseus House or another entity that wanted to use this land. So I just can't see where this is not going to increase traffic in our neighborhood, and it's already bad. One other thing about the streets, come visit us, they're in horrible shape. Dexter is a 2-lane road, and it's not in great shape. 41st, 42nd, they're not well maintained, and Dexter being a 2-lane road right now, residents park on the street. If we increase the traffic on Dexter, which this will do, that's going to exacerbate that problem for those residents. I'm not sure whether parking's permitted or not, but it's done. So I think traffic is an issue, and most of our neighbors, I believe, would agree to that. I just want to touch briefly on property values. It's my understanding that last night...
I'm gonna ask you to hold up here for a second, okay? Because you're making arguments that other people have covered, okay? And also that really don't bear on the question of zoning, okay? I wanted to give you leeway on the traffic. You want to talk about property values. I understand you're concerned about property values. What is the other subject matter? You said you had 3 points.
The tax exempt status.
Okay. And again, those are things that do not bear on the zoning at all. Okay. Attorney Ivan?
Yeah, Gary Ivan for the record. I just make sure that I am on record as stating those objections that you just expressed.
Okay. And again, I don't mean to cut you off here. If you've got something that deals with the zoning aspects of this, we'll be happy to hear them. But we've had a record established from the last time that addressed some of these same concerns. If there's anything new or different that you have to add.
Can I ask a question?
Sure.
Were property values and the tax exempt status discussed at all?
Yes.
And can we be informed as to that?
I mean, they're going to be part of the record in terms of the transcript that will eventually be produced here.
Okay.
But there were people who did express concerns about property value. And I've heard several people ask about the tax exempt status. And my understanding is that Perseus House is a tax exempt entity and that these properties would be tax exempt.
Great. And my only comment about that would be that I believe we have enough tax exempt property. Mike, I have one question. Are there currently tax exempt, properly zoned properties in the city where this project could be built? Is there a plan B? Does Perseus House have a plan B if for any reason this doesn't work out?
I don't know. I don't represent Perseus House.
Can we answer that question?
And in terms of...
I'm not here to answer your question.
Yeah. I mean, so, yeah. In terms of whether or not there's a plan B, that's really up to Perseus House. I don't know that it would matter whether or not the properties don't get zoned tax exempt. If a property is owned by a tax exempt entity, they can apply for a tax exemption for the property. But there's no tax exempt zoning district in the city of Erie. It's a question of who owns the property and whether or not they are a tax-exempt entity.
So essentially, this would be added to the approximately $1.4 trillion of tax-exempt properties in the city?
I don't know that your numbers are correct.
They're from the budget, from the city budget.
$1.4 trillion?
1.3, close to 1
trillion.
Now, that includes hospitals and universities and all of the things needed in a community.
Trillion.
Yes, that's what I read.
Well, regardless, we don't have any control over that.
Yeah, that's not the zoning.
Well, let me
board.
just state then for the record that what's been mentioned already, this development will definitely change the character of our neighborhood. And to me, it sounds like the developer, as the previous speaker said, they're trying to scare us with what might be built there as opposed to what they want to build there. And nobody knows what might be built there.
Right.
We understand.
Yep.
Okay?
Thank you for your time.
All right, thank you.
Anybody else who wishes to be heard that hasn't been heard? Okay. At this point, we
There's a
need
lady
to-
with her.
Well, Attorney Iben is going to present some legal argument.
There's one more.
Oh, one more?
Right here.
Okay. Come on up, man.
I think that we covered one of that, but as
Ma'am, you've got to.
Barbara Matlack, 4103 Dexter Avenue.
Okay, now wait a second. Raise your right hand and the court reporter will swear you in.
You swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. He told me that there was, in that,
Who's he?
okay, the realtor. And he said that they looked in the area, there was nothing in the area that they could buy. Then as we were kind of saying goodbye, he says, oh, by the way, did you know that the plaza up there is for sale? And part of the plaza is a U-Haul. The other one has some tenants on there, that one where the jumping thing, and we have an ACL, we have a Chinese restaurant, we have a pizza shop. But it has access, there's bus service right there, and they complain, they were concerned about bus service. There's
Are you in favor of this Percy's house or?
I am against it.
Okay.
Okay, but it's just right to the south of where they want to build. They could go there and they would have, there would be a space between the residential and the other parts, where they would not be bothering anybody. And they could build the buildings. The one building is huge because it has that flying, whatever it is, exercise thing. They could adapt that to a gym. The right next to it is, used to be.
So you understand, we can't tell Perseus House to go and buy another property.
Well, all I'm saying is they told us there was nothing.
Okay.
And there is something that they may want to consider. We have East Grandview that has a lot of traffic that they could go up, not bother anybody. Parking, they could tear down the one part up there and put in housing. There are other things that, and then maybe they could, whatever they do with that small, not wide section, they could put in maybe a plaza for the people that they already taken out.
Well, we were getting off a little off track.
Okay, but all I'm saying, there is an alternative. And they said that there weren't any alternatives.
I understand your perspective.
Thank you.
Okay, thank you.
Is there anybody else?
Okay. Attorney Iben, if you want to present argument?
I do. Thank you very much. Again, for the record, Gary Iben, counsel for Perseus House in this matter. And one of the nice things about getting to the end of a hearing is that kind of issues sort out and filter out, and you can kind of distill what you want to say and keep it as short as possible, and that's what I will try to do here. And first, because I've been sensitized to your concern about it today, I do want to address the standard factors for a variance because they don't apply here. This is not the normal case involving the normal factors for a variance. We have essentially two arguments in favor of the variance. The number one has to do with the decision by the zoning officer that this qualifies as a group care facility. Maybe that's accurate. I don't really have a fundamental problem with that. But then there's a second implied conclusion there that it doesn't qualify as a group home. But if you look at the definition of a group home, we meet both of those requirements. And so simply as a matter of the interpretation of the ordinance, we believe that that decision should be reversed and a variance should be granted. It quite simply says a group home special exception is reasonable accommodation, that's what we have. Group living arrangements for handicapped persons, that's what we have, as defined by the Fair Housing Act, so long as the facility abides by city codes, etc. I'm going to stop on that language defined by the Fair Housing Act because that's going to become a very important concept here. A lot of people may think these are highly technical arguments that we're reaching for, but these are highly technical arguments based upon very fundamental concepts in the fabric of American society. And it has to do with equal treatment of everyone. That includes handicapped people, and under the Fair Housing Act, handicapped people includes those who have mental health needs, such as what we're dealing with in this case. So we meet the requirements of a group home, even if we are also a group care facility, even if we are a group home. So, both of those we meet, and therefore we should be permitted to proceed forward. But there is the alternative here. Okay, let's say that the zoning officer was correct in his determination that this actually qualifies as a my definition's correct. A group care facility, which is an establishment providing room and board to persons. That's similar to the definition under the group home. Residents, by virtue of receiving supervised specialized services, you've heard the discussion, these residents will receive those specialized services. They are for health, social, rehabilitative, or housing services. We need at least three of those, health, social, and rehabilitative. Probably some need housing services. Provided by a government agency, okay. We do not meet the government agency part, but then we get into some other very interesting language, as noted by your counsel at the last hearing. They are licensed or certified agents. Their licensed or certified agents would refer back to government agency. And finally, or other responsible nonprofit social service corporation. Now, as counsel pointed out, Attorney Martinucci, there's no comma there. It sounds very much like other responsible nonprofit social service corporation is going to have to be an agent of a governmental agency. And we're not an agent of a government organization. We do get some funds from government organizations, but we're not an agent of them. If that's the case, then your real fundamental problem, not as a factual matter, but as a legal matter, is there is no zoning district in the city of Erie which allows for a facility for group care. And that is the real fundamental problem that you have. We are challenging this particular language and the structure of this ordinance on the grounds that it does constitute exclusionary use. Exclusionary uses have been a subject of a lot of cases for a lot of years. And again, I know that Attorney Martinucci is very familiar with those, and I don't think I need to get into too much detail with them. It's really a very basic concept that we all understand. Is a legitimate use being excluded in the municipality that's at issue? And that's what this ordinance is now doing. It does not permit, as a legal matter, any place for us to do a very legitimate use. And its legitimacy, again, is proven by the terms of the Fair Housing Act, which have provided protection to individuals such as those that Perseus House will be caring for. And that is going to be a real big issue if we can't get the variance, because there will be...
I think we heard enough.
All right. Thank you very much.
Sure. Okay. Yep.
Take a short recess.
Thank you. Do we have a motion?
Call the vote.
Okay, we're going to call for the vote. Motion to approve?
Well, yes.
To approve, correct. Ms. Gunchen?
Based upon the testimony today, I am going to vote to deny the variance request based upon the fact that it is my opinion that the appellant qualifies as a group home. It is not a group care facility nor a group residence facility as the ordinance is written. Again, the importance of the Oxford comma. And a group home is permitted in the R3 district under the City of Erie zoning ordinance.
Ms. King?
I also echo my colleague's sentiments, so I will be denying the variance as written because a group home is permitted in the R3 district as written in our city's zoning code.
Mr. Dawson?
I'm going to deny and believe that it to be a group home at this time.
And Mr. Johnson?
And I'm going to deny the request for the variance, also due to the fact we do believe it is a group home and permissible in an R3 district, which this is. So with that said,
Motion for the variance has been denied. And is that correct?
Well, that is it, but to be clear, so there's no question here. The board has also determined that based on the evidence presented at the last hearing and today, that the facility is a group home, which is permitted use in R3, and therefore no variance is required.
Okay. All right.
So we will be filing a new application, just so everyone is aware, and we will expect the zoning office to adhere to the directives of the board in that regard. Thank you very much.
thank you. Meeting adjourned.